Good morning, ladies and gentlemen. Welcome to the Public Service Commission of South Carolina. We're here in docket number 2019-212E. Let's take a brief moment of silence before we get started. Thank you. We're going to take roll. Present in the hearing room, we have Commissioners Caston, Thomas, Powers, Belzer, and Jay Williams. Joining us virtually, we have Commissioners Irvin and C. Williams. Attorney Stark, if you would please, sir, read the docket.
Thank you, Mr. Chairman. Mr. Chairman, other commissioners, we're here for the proceeding in docket number 2019-212-E, which concerns the South Carolina Energy of Freedom Act proceeding related to Dominion Energy South Carolina Incorporated for commission review of the community solar programs established pursuant to Act 236 of 2014 and to solicit status information on existing programs from the electric utility. Mr. Chairman, this proceeding's been scheduled for Thursday, September 23rd, 2021 at 10 a.m. to be held virtually. Mr. Chairman, I believe the docket to be in order.
Thank you, Attorney Stark. Before we have the applicant present their case, are there any preliminary matters that we need to address? All right, hearing none, applicant, if you would please call your first witness.
Mr. Chairman, I think Commissioner Williams was trying to say something. She may be on mute, so I'll just stand by until called upon.
Thank you, Attorney Burgess. I didn't even see that. I'm sorry, Commissioner Williams. Commissioner Williams, please go ahead.
Thank you, Chairman Williams, and I appreciate that as well from Dominion. Chairman Williams, I am one of the applicants on the waiting list for the current community solar program that was authorized via Act 236. Clearly, I have a personal interest in Dominion Energy South Carolina's community solar program. Personally, I'm not at all concerned about my ability to be objective in this case, but that's not the question. The question is from the Code of Judicial Conduct, whether my serving in this hearing would benefit me or create, in any reasonable mind, a perception that my ability to carry out judicial responsibilities with integrity and impartiality is impaired. So to avoid any impropriety or the appearance of impropriety, I'm recusing myself from this hearing. Thank you.
All right, understood, ma'am. So Commissioner Carol Lee Williams of the 1st Congressional District is recused, and I would expect for Commissioner Williams to sign off. All right, since we had that, let me do this. Let's take appearances. Who's here for Dominion Energy South Carolina Incorporated?
Good morning, Mr. Chairman and members of the commission. My name is Chad Burgess, and I'm in-house corporal counsel for Dominion Energy South Carolina. And with me today is the company's outside counsel, specifically Sarah Hutchins. Ms. Hutchins has been admitted to appear before you, pro hoc vici, and her local counsel is Ashley Cooper. They are both from the law firm of Parker Poe. It's a pleasure to appear before you today, and we appreciate the opportunity that you have given us to present the company's case in this matter. Thank you, Mr. Chairman.
You're welcome, sir, and welcome to your legal team. Happy for you all to be here. South Carolina Solar Business Alliance Incorporated, I believe, intervened, but they are not appearing. The South Carolina Department of Consumer Affairs, received notice of this hearing, but did not intervene. And that brings us to the Office of Regulatory Staff.
Good morning, Mr. Chairman, members of the commission. Representing ORS is myself, Andrew Bateman. Thank you.
Good to see you again, Attorney Bateman. Thank you for joining us this morning. All right, applicant, if you would please call your first witness.
Thank you, Commissioner. Mr. Chairman, Dominion Energy South Carolina calls Mark C. Furtick to the stand.
Mr. Furtick, if you would take the witness stand and pause to be sworn in by our court reporter.
Mr. Furtick, if you would raise your right hand, please. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Mr. Furtick, please state your name for the record.
Mark C. Furtick,
And by whom are you employed and in what capacity?
Dominion Energy, South Carolina. I'm the Renewable Energy Programs Advisor.
Have you prepared or caused to be prepared under your supervision direct testimony of 13 pages that was previously filed with the Commission on August 12th, 2021 in this docket?
I have.
And do you have any changes or additions to your pre-filed direct testimony?
I do not.
If I asked you the same questions here today, would your answers be the same?
They would.
Mr. Chairman, at this time, I move that the pre-filed direct testimony of Mr. Furtick be admitted into the record as if given orally from the stand.
The pre-filed direct testimony of Mr. Furtick will be entered into the record as if given orally from the stand.
Thank you, Mr. Chairman. Mr. Furtick, have you prepared a summary of your direct testimony?
I have.
Would you please deliver it at this time?
I will.
Thank you, Mr. Furtick.
Good morning, Chairman Williams and members of the Commission. I am the Renewable Energy Programs Advisor for Dominion Energy, South Carolina, and I'm here today to describe DESC Community Solar Program, which was approved by the Commission in 2015. Previously, I helped develop and have responsibility for DESC DESC customer scale renewable energy programs, including DESC Community Solar Program, Distributed Energy Resource Program, that was approved by the Commission in Order Number 2015-512. DESC Community Solar Program allows customers who do not want to install or cannot install solar panels access to solar energy through purchasing or subscribing to a portion of the energy output of one of 3 community solar energy generating facilities on the DESC system. DESC Community Solar Program was enacted in compliance with Act 236, the Distributed Energy Resource Program Act of 2014. Act 236 was critical to the development of DESC Community Solar Program because it permitted cost-shifting mechanisms and allowed utility companies to recover any reasonable costs related to their investments in these programs. DESC Community Solar Program focuses on 3 types of customers: residential customers, low-income customers, and tax-exempt non-residential customers. Residential customers are individuals who are seeking to receive the benefits from this program. Low-income customers are individuals who are seeking to receive the benefits of this program and meet certain household income requirements. Tax-exempt non-residential customers are comprised of qualifying municipalities, churches, and schools. Since the program's inception in 2015, DESC has recruited these customers to the community solar program through social media posts, by publication in DESC e-newsletter, at conferences, on DESC website, through direct mail, press releases, and billing inserts. DESC low-income customers may also be referred to the program through community organizations in addition to the above efforts. Participating DESC customers receive a bill credit each month for their pro rata share of the community solar farm's energy production that is valued at a predetermined credit rate. Residential and tax-exempt non-residential subscribing customers pay a subscription fee each month, which is offset by the credit. These customers may also purchase interest in panels and then receive a monthly credit. Low-income participants are not required to pay a fee, and they still receive a credit on their monthly bill. Demand for the program is only moderate. As of August 12th, 2021, there are 163 low-income customers participating in DESC Community Solar Program, with 0 low-income customers on a wait list. There are 840 residential customers in the subscription program and 37 residential customers in the purchase program. There are currently 36 residential customers on the wait list. There are 19 municipal rate customers, 16 school rate customers, and 12 church rate customers in the tax-exempt non-residential subscription program. These customers may sign up for additional non-residential capacity when it becomes available. Under the Community Solar Program allowed through Act 236, cost of the Community Solar Program for residential, low-income, and tax-exempt non-residential customers are subsidized by all customers whether or not they participate in the Community Solar Program. Subsequent legislation, specifically under the South Carolina Energy Freedom Act, or Act 62, expressly prohibits cost shifting for any successor community solar programs DES may develop. My colleague, Witness Cassis, will discuss Act 62 in further detail. As required by the legislature, DES has provided updates to this commission on its community solar program, including in November of 2019. The update sets forth the limitations on expansion of DES community solar program due to the restrictions of Act 62, which Witness Cassis will detail. In conclusion, DESC is committed to its many renewable energy programs and will continue to promote these programs, including the community solar program, within the avenues permitted by the South Carolina legislature. I thank the commission for its time. This concludes the summary of my direct testimony.
All right, thank you, sir. Any cross-examination by the Office of Regulatory Staff?
No cross, Mr. Chairman.
All right, questions from commissioners. Commissioner Powers.
Thank you, Mr. Chairman. Good morning, Mr. Furtick. How are you today?
Good morning, Commissioner. I'm great. How about you?
I'm good, thank you. I was just, in hearing your testimony just now, just wondering, you mentioned there were some pending applications or pending decisions to be made. What will happen to those if this commission does not require further community solar programs in any way?
Commissioner, I'm struggling to hear you just a little bit.
I'm sorry.
I think you asked about people on the wait list and what might happen going forward. So
That's it with the waiting list. What would happen with the waiting list?
Okay. The community solar program as is, it has a 20-year term, and it will continue until that time unless this commission decides to stop it or the authorized community solar developer asked to get out of it. There's also a 15-year extension. So again, we're reporting on the progress of the program to date, and there's no plan, and I don't think this hearing is about whether to keep that program. As far as I know, the program will continue as is.
Thank you, sir. Thank you, Mr. Chairman.
Any more commissioner questions for Mr. Furtick? Commissioner Caston.
Thank you, Chairman Williams. Yeah, good morning, Mr. Furtick.
Good morning, Commissioner.
Just out of curiosity, I noticed that the facilities were, I guess, developed in Orangeburg, Jasper, and Hampton counties. Any particular reason they were developed in those counties?
No, sir. So those facilities are owned by the community solar developer. DESC does not own the farms, and they procured those locations as a normal utility scale developer would. I'm assuming one big driver of that would be the cost for the property. I think that's the main driver for the locations.
All righty. Thank you, sir.
Questions for Mr. Furtick? Mr. Furtick, I'm sorry, who was that?
This is Commissioner Irvin.
Commissioner Irvin, you have the floor, sir.
Thank you. Mr. Furtick, good morning, sir. How are you?
I'm good. How about you, Commissioner?
Good. What reasons do you think the participation rate was so low in this particular community solar program?
Well, with all respect, sir, I think the participation is high. We are at the levels that we applied for. All 16 megawatts is subscribed. What I will say is our waiting list levels have varied over time. Right now, they're fairly low, but the participation level has been high. I mean, we're fully subscribed in the program as it was approved.
I was listening to your testimony, and I thought you said that there were 0 low-income participants. Did I get that wrong?
There are 0 low-income customers on the wait list. I will verify, but I believe we have 163 low-income participants participating.
All right, sir. Thank you for that clarification. No further questions.
All right. Mr. Furtick, I have a question for you. It's a little outside of the box. I understand the petition and I understand the law, but I'm just curious to know if there's any innovative out-of-the-box way to expand this program. Maybe something that is non-traditional that we're not thinking of. Is there any way to expand it without creating a cost shift?
So I believe my colleague witness Cassis will address this as well, but I'll just say with the current price levels in the market, the current tax credits in place, and the current regulatory structure, I'm not aware of a way we could do it and make it cost beneficial for the participants and not have cost sharing.
Understood. Thank you, sir. All right. If there are no more questions for Mr. Furtick, we can ask for redirect if necessary. Any redirect?
Thank you, Mr. Chairman. Just one clarifying question. Mr. Furtick, you were asked about the waitlist by the commissioners, and just for clarity's sake, when a participant moves out of the service area and there are customers on the waitlist, what happens?
The next customer on the list would be eligible to receive the space or the capacity in the farm.
Thank you, Mr. Furtick. I have no further questions for Mr. Furtick, Mr. Chairman.
All right, ma'am. If there's nothing else from Mr. Furtick, you may step down from the witness stand and you are excused, sir. Applicant, if you would, please call your next witness.
Thank you, Mr. Chairman. Mr. Chairman, Dominion Energy South Carolina calls Daniel F. Cassis to the stand.
Mr. Cassis, if you would take the stand and pause to be sworn in by our court reporter.
Mr. Cassis, if you would raise your right hand, please. We seem to have lost your video. There you are. If you would raise your right hand. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Mr. Cassis, please state your name for the record.
Daniel F. Cassis,
And by whom are you employed and in what capacity?
Dominion Energy, South Carolina, and I am the General Manager of Strategic Programs and Renewables.
Thank you. Have you prepared or caused to be prepared under your supervision direct testimony of 8 pages that was previously filed with the Commission on August 12th, 2021 in this docket?
I have.
And do you have any changes or additions to your pre-filed testimony?
I have no changes.
If I asked you the same questions today, would your answers be the same?
They would.
Mr. Chairman, at this time, I move that the pre-filed direct testimony of Mr. Cassis be admitted into the record as if orally from the stand.
The pre-filed direct testimony of Mr. Cassis will be entered into the record as if given orally from the stand.
Thank you, Mr. Chairman. Mr. Cassis, have you prepared a summary of your direct testimony?
I have.
Would you please deliver it at this time?
I will. Good morning, Chairman Williams and members of the Commission. I am the General Manager of Strategic Partnerships and Renewable Energy for Dominion Energy South Carolina. I oversee customer-facing solar and all renewable energy initiatives for DESC and was the principal designer of the DESC Community Solar Program under Act 236, which fulfilled requirements for a program for certain types of customers. The purpose of my testimony is to describe how Act 62, passed in 2019, impacts future iterations of DESC's Community Solar Program. Act 62 limits DESC's ability to expand the program as it exists today. A successor Community Solar Program is not a viable option under Act 62 because of Act 62's prohibition on cost shifting. The General Assembly specifically restricts DESC and other utilities from further enacting cost shifting mechanisms that were crucial in establishing the current Community Solar Program. This is different than the provisions the South Carolina legislature set forth with respect to solar choice, which only directs the Commission to eliminate cost shift to the greatest extent practicable. The cost of participation spread among only the participants would be too great, diminishing interest in the program. even where costs are non-existent, such as for qualifying low-income customers, demand for the program remains low. Legislative and market changes in the form of tax credits, aggressive drops in labor and material costs, rate design, and other financial incentives is necessary to allow and expand this renewable energy offering. In conclusion, DESC is committed to its many renewable energy programs and will continue to promote these programs, including the community solar program, within the avenues permitted by the South Carolina legislature. I thank the commission for its time, and this concludes the summary of my direct testimony.
All right. I'm sorry. Do you have further questions, Attorney Hutchins?
No, Mr. Chairman, at this time, Dominion does not. As no other party has filed direct testimony in the docket, the company did not file any rebuttal testimony. Mr. Cassis is available for questioning by the commission.
All right. Thank you, ma'am. Office of Regulatory Staff.
No cross-examination for Mr. Cassis, Mr. Chairman. Thank you.
All right. Commissioner questions for Mr. Cassis. Commissioner Caston.
Morning, Mr. Cassis.
Good morning.
I was noting on page 5, lines 13 through 18 of your direct testimony, you state the incremental cost for the existing community solar program was $2.2 million in 2020. Is that correct?
Yep, that's correct.
And can you give me an example of what some of those incremental costs would be?
Yeah, sure. The incremental costs are just the cost above costs that are avoided. So the developer, in our case, as witness verdict mentioned, there are 3 solar farms that are part of the program. They deliver energy, but they also get compensated for the delivery of that energy above avoided cost. And then some of those dollars then get shared with the participants, either the subscribers or the owners.
Okay. So that you're going to say that $2.2 million without absent the cost shift or the allowable cost shift would be divided up over 1,087 customers, correct?
If it was, if you follow the statutory requirements in Act 62, that's how the economics would work. In Act 236, those costs get spread throughout the entire program, so all customers don't pick up those costs.
Right. So that would have been roughly $2,024 more for each one of those 1,087 customers.
I think your math is accurate.
Well, that's pretty basic math, so that was easy for me. Thank you. And on page 8, lines 5 through 7 of your testimony, you state that, however, from this point on, it becomes increasingly more difficult and complex to increase renewable energy in a cost-effective manner that does not reduce or hinder reliability. Can you elaborate on that some? Relative to, I guess, reducing and hindering reliability.
Yeah, so as we add more and more renewables, and I think, as I noted above in my direct testimony, that we've already integrated over 1,000 megawatts. So every additional megawatt that gets integrated, it interacts, whether it's in a community solar setting or utility scale, all those megawatts essentially interact. So they're all delivered on the system. So as you add more of that same type of resource, it's impacted by what's already on the system. I think that was the intent of what I wrote in the testimony.
And by impact, you don't necessarily mean negatively impact, but there's a consequence of that, and the consequences are or could be what?
Yeah. So you've got to integrate it. So as you integrate more, it's intermittent. You've got to have a place to put it. So it requires really integration costs to be able to deal with, and including it could be up to curtailment if you don't have a place to put it.
I understand. Thank you, sir. No more questions.
Any more questions for this witness?
Mr. Chairman,
Commissioner Thomas.
thank you. Good morning, Mr. Cassis.
Good morning, Commissioner.
Appreciate you being here. So basically, I guess my question is, are there any potential benefits that you can see to keeping this docket open?
Yeah, Commissioner, I had trouble hearing the last part of your question.
I was saying, are there any potential benefits to keeping this docket open?
At this point, I don't see so. I don't think so. I think that, as a company, you're probably fairly clear on our record regarding the 1,000 megawatts, the fact that we are the second in the Southeast in terms of total watts per customer. So we think we're committed to keep this program, the Act 236 program, and we're also committed to look forward to the future if things like policy and aggressive price drops take place, et cetera. But at this point, I don't see a point in keeping the docket open.
And do you see any costs associated with keeping the docket open?
No, I mean, we're already committed for the Act 236. Those resources, those go into the DER program. So, I mean, to me, it's a clear break between what Act 236 was set up to establish in that program, and then now going forward, what Act 62 requires with respect to costs that have to be borne by participants.
Okay. Well, how about just simply administrative costs of keeping the docket open?
I wouldn't know I'm not sure how to answer that, although we have costs that we continue to incur with the existing program, but for the docket itself, I would note that in Act 62, there's really no sunset provision. So let's just say we're in a future date, maybe it's 2027 or 28, or there's some future period where there's aggressive price drop, there's policy change, there are legislative changes, then the program could become viable. So there's nothing that I think stops us from coming back with a program if it can meet the requirements.
Okay, thank you. That's all I had.
All right. Any more questions for this witness? Sir, I'm going to ask you the same question I asked Mr. Furtick regarding any innovative, out-of-the-box, non-traditional or untraditional methods of expanding this program.
Yeah, I'll answer it like this, Commissioner. The things that I just mentioned to Commissioner Thomas, I think those are, the way our program worked, the original program, we were one of the first ones to really think about community solar with scale. And so that's one thing that could help the program in the future if you thought about a program that had scale. But at the same time, scale in the absence of price reduction is, it fails the non-participant cost tests that we've got to deal with. I think there could be legislative changes that could help the program. I think there could be federal policy changes that could help the program. But those are the things that are, having looked at the original program and helped develop it, and I know where the costs are, you know the levers that have to change in order to get it to be competitive. And I think those are, I've described the areas where I think it could become competitive. Not to say it won't be in a future year, it just isn't now.
Understood. Thank you very much.
Chairman Williams.
Commissioner Caston.
As a follow-up on that, Mr. Cassis, and you mentioned that in your pre-filed and a couple of times here, unless there's aggressive price drops, and I'm assuming in the cost of materials and construction and such, and policy or legislative changes, and by policy or legislative changes, I assume that means in the form of some tax credits. Is that correct?
Yeah, I was referring primarily to tax credits. It could be at a state level. Primarily the way the original program got more competitive and actually helped reduce the cost shift was as a result of tax credits. So I'm not, I guess, deeply engaged in federal policy, but policies at the federal level or at the state level, which would then help reduce the cost or assist with the financing of the project, that could create a construct that could be beneficial and could get you to you could get closer to that point. Don't know if you can fully get there, but that would be the way I would be thinking about it.
One could some not argue that that's another form of cost shift?
I could make that argument. And so the way the model works is that we're in these projects, we're the buyer of the energy on behalf of the consumers that are subscribers or buyers, and so it's a mechanism to help finance the asset. Okay. So the assets, in the end of the day, someone's capital goes into those projects. Not as much the participants in the program, but a solar developer puts or has to go acquire capital, whether it be tax equity or whether it be debt.
Understand. So what I think I'm hearing is absent aggressive price drops or something in the form of tax credits or whatever on the state or federal level, that the current program is not viable.
Well, yeah, extending the program to under the Act, 62 construct is that's where the limitation is, correct.
Okay, I understand. Thank you, sir.
Yes, sir.
Mr. Chairman.
Commissioner Irvin.
Thank you. Mr. Cassis, good morning, sir.
Good morning.
Let me get some clarity on the concern about the cost shift. Why couldn't this program continue with didn't Congress extend the investment tax credit for solar developers? Haven't they done that already?
So the federal tax credit is currently at 26% for utility scale.
So it's still available?
Oh, it absolutely is, yeah.
Okay. So why would it not be profitable for the developer to construct a new facility and sign up on the avoided cost rate?
It would require that they hit certain price points. And the math that we um, look at doesn't get them to financeability on especially on small projects like this. So our projects are 6 and 8, they're distribution interconnected. So as you get bigger and bigger and get more scale, the price drops. But it's not, these projects were, and I'm adjusting these projects for current build price, but for small projects, neighborhood and community, they're still much more than utility scale solar. It's not the equivalent of a 75 megawatt.
All right. So what if a municipality or a county came to you and said, we will donate some land, maybe over a landfill or a existing property that they already own. We'll donate that property for scale up of this program, and you could put out a request for proposal for solar providers to bid on building the solar panels and interconnected under the grid at avoided cost. Would that work?
If they could get to avoided costs. So the construct I think that you're describing would mean that the land would be free. They would also have no property tax. They would also have to make sure, and the developer would be responsible for the operations and maintenance. They would also have to interconnect it, and they'd likely have to be probably in the range of about all in cost with tax credits, probably around 70 cent per watt, 70 cent per watt DC, less than $1 to get to basically to the avoided cost numbers, which would then, that would be the break even, but still wouldn't give the participants benefit. It would just break even. It would be equal to the avoided at that point.
Okay. So let's assume for the purpose of this discussion that solar panels continue to drop in price. How much further would they have to drop to make the package work? Have you done the math on that? Do you have an estimate or guesstimate?
Yeah, and in looking at this analysis and trying to determine really how we could make it work, panels are probably right now, it depends on, when you buy the panels, if you had the panels, the tariffs, et cetera, but you're in the 20 to 30 cent per watt range. The labor is likely considerably above that, especially for small projects. Even on utility scale, you're probably 70 cent per watt just on the labor on really big projects. That's the math just isn't there on the install cost per DC. You really have to drive that down to then get to that, what I would call parity, where there's no cost shift.
Okay. So, and this is taking it one step further. What if all or part of the labor could be donated by nonprofits or others, that were qualified to do the install? Does that make it closer to profitability?
If they donated the labor, let me do the quick math. So our biggest utility scale solar farm is about 8 megawatts. So 8 megawatts, if they donated labor and it was 70 cent per watt, it'd be about 5.6 million is what their donation would be.
That's a large chunk of change. But theoretically, there may be an individual or a community foundation or a nonprofit that might be interested in supporting it. If something like that came to pass and somebody came forward and said, we'd like to make this happen, that might be an opportunity to make it work.
Commissioner, if you know someone with 5.6 million, could you have them call me directly? I'd like to work with them. Yes.
Good, yes, sir. That might be an ex parte contact. How about if I have my staff contact you?
Yes, sir.
I have noticed that some of these billionaires have been fairly active in this area, so it's not out of the realm of possibility, but I have to agree that it's probably not on the very top of their list. But I appreciate your entertaining this discussion, and I have no further questions, Mr. Chairman. Thank you.
All right. Any more questions for this witness? Redirect.
Thank you, Mr. Chairman. The company has no redirect at this time.
All right, sir, you may step down from the witness stand and you are excused.
Thank you, Mr. Chairman. That concludes the company's case in chief. We have nothing further at this time.
Thank you, ma'am. Office of Regulatory Staff.
Thank you, Mr. Chairman. ORS has nothing at this time.
All right, ladies and gentlemen, it appears that we have come to the end of this hearing. If there's nothing else, we are adjourned.